The Evans Law Group, providing a full spectrum of family law services.
You know, it's a very common question about where to file. If I'm looking to file for divorce and the couple were married somewhere outside of the state of Texas, the basic requirements in terms of being able to file in Texas is that one of the parties or both of them have lived in the state of Texas for at least 6 months and has lived in the county where you choose to file, in our case Williamson or Travis or Hayes or Bastrop counties, for at least 90 days. As long as those requirements are met, then you can file here in the state of Texas. It doesn't matter really where you were married. In fact, the question of where you were married has very little to do with whether or not you can file for divorce in the state of Texas. It has very little, if nothing, to do with whether or not you can file in the state of Texas. There's really the two central questions. One, do you meet those criteria? Has at least one of you lived for 6 months or better in Texas and 90 days in the county that you're going to file? And then two, does the state of Texas have what's known as personal jurisdiction over both parties? That's really the bigger question. If you were married, say, in Tennessee, hypothetically, and one of the parties has moved to Texas and has been living here, but the other spouse never set foot in the state of Texas, children were never born here, you don't own any real estate here together, you never really acted as a married couple here, the other spouse just never lived here, or has really never been here or conducted business in the state of Texas, you run into a bigger issue, which is known as personal jurisdiction. Now, we have jurisdiction over you as a party because you've lived here for 6 months and 90 days, but the other spouse has never, we would not be able to establish personal jurisdiction over the other spouse. That then becomes the bigger question. And so if that's your situation, you want to carefully consult with an attorney because there are exceptions under what is known in Texas as our long-arm jurisdiction statute. And you want to create the ability to give the courts the power of personal jurisdiction over what we call the foreign spouse, which is a spouse that lives outside of the state of Texas. And there are ways to do that. There are creative ways to do it under that statute, but you need to consult with an attorney carefully about how to do that because you may end up finding yourself where you have to just file in the other state. But again, it has nothing to do with the fact you were married in Tennessee. It has everything to do with the fact that Texas would not have personal jurisdiction over the other spouse.
When life's path takes an unplanned turn, call the Evans Law Group for a consultation at 512-628-2550. The Evans Law Group, providing a full spectrum of family law services.